Thank you. You may be seated. We are here today in our case number 1, CACV 160471, Wasserman versus MOYA. Each side will have 20 minutes. Appellants will be responsible for reserving any time you'd like for rebuttal. These proceedings are being audio and video recorded, so we would ask that you identify yourself and your client the first time you approach the podium. We have read the briefs. We've conferenced this matter already, and we look forward to your argument. With that, you may begin.
Good morning, Your Honors. My name is Erica Gadberry, and I am here on behalf of Crystal MOYA, who is the appellant in this case. Your Honors, this case has 3 issues. The first issue is that the trial court erred when it failed to award wife with an indefinite award of spousal maintenance. The trial court also erred in the amount that it temporarily ordered wife. And third, the trial court erred in the amount of money in the amount of attorney's fees that it awarded wife. So starting first with indefinite spousal maintenance. Arizona's spousal maintenance policy is relatively clear. The purpose of it is rehabilitative. Hopefully, the award will be temporary, and it will allow the dependent spouse to become independent of the providing spouse. When that can't occur, the presumption is indefinite spousal maintenance.
Isn't that presumption, hasn't that been raised in cases where there's been a long marriage where one of the spouses may have put the other one through college or has stayed home raising children and otherwise contributed to the marital community? Doesn't that suggest a different fact pattern maybe than this case?
I respectfully disagree with that because the Arizona has a strong public policy of not allowing a person to be on any sort of public assistance. So, for example, in Schroeder v. Schroeder, the Supreme Court of Arizona stated, if the purpose of spousal maintenance is rehabilitation, the duration of the award at the time of the decree represents a prediction of when self-sufficiency will be accomplished.
Let's think about it, though, in terms of what if it were a 1-month marriage? And certainly those same factors would suggest an indefinite award. But do you agree that it's a discretionary call with the trial court, and maybe with a marriage of 1 month that there might be a different result than if it's a 30-year marriage?
Well, again, I think that you need to look at the purpose behind spousal maintenance. So when you get married, you assume a risk that you're going to be responsible for that person indefinitely. That is relevant in the prenuptial statutes that we have, wherein even if you negotiate a prenuptial agreement that states neither party is going to be responsible for any spousal maintenance, and then the trial court finds that one of the parties will end up on public assistance because of the lack of spousal support, that portion of a negotiated, essentially, contract can be vacated in order to prevent a party from being on social assistance. It's also, you can also see that on the backside, whereas when you have an award, a temporary award of spousal maintenance that's made, and circumstances change and maybe one of the parties gets cancer or some other disease, they can end up with indefinite spousal maintenance. So irregardless of the length and term of the marriage, if somebody's going to end up on social welfare, as wife is in this case, spousal maintenance is appropriate.
So you're saying that if your client prevails in this matter and gets this indefinite spousal maintenance, she's going to politely decline the public assistance she's entitled to under Social Security?
If husband can meet her reasonable needs, then she won't need the Social Security. But in this case, all wife is asking for is to be able to meet her reasonable needs.
Well, what's the best case? What's the closest case that you think is on point that suggests that the award is not determinative on how much a spouse has contributed to the to the community?
Well, we have a case, Oppenheimer v. Oppenheimer, and in that case, the marriage was 40 months, which is a little under 3.5 years. And in that case, the wife was awarded 17 years of spousal maintenance. We also, in Rainwater, they specifically say, although Arizona courts have stated that public policy favors fixed-term maintenance as a mean to promote a diligent effort to become self-sustaining, we have repeatedly cautioned that this goal must be balanced with some realistic appraisal of the probabilities that the receiving spouse will in fact subsequently be able to support herself in some reasonable approximation of the standard of living established during the marriage. So again, we have Gutierrez also reaffirms that, as well as Schroeder. So each of those
It's
cases.
something that can be taken into it's a factor that can be considered. How much the spouse contributed to the community. One spouse put the other one through college, stayed at home raising kids. Isn't that a relevant factor in determining the amount and the duration?
I agree it's a relevant factor, but it's not the only factor. In this case, we have explicit findings from the trial court that wife is disabled. She's unable to work. She can't meet her reasonable needs. I mean, these were explicit findings. There's no dispute on these because the trial
But
court
there's also no
found that.
dispute about whether she contributed to putting spouse through college or otherwise stayed at home to enhance his ability to earn income for the community.
And I agree, but again, I think that you need to go back and look at whether or not she can meet her reasonable needs or whether she will be able to meet those
Seems to me
reasonable needs.
you're just focusing on one factor alone if there's several factors, and if it's an abuse of discretion review that we're under, if there are a number of factors that the court considered, why should we ignore all of them except she's currently disabled?
It's an abuse of discretion, but again, you have to look at it within the realm of the law. And if you don't do that, then that's a mistake of law. And when a spouse is unable to be self-sufficient, unable to support themselves, indefinite is the presumption, according to Rainwater and Schroeder and Gutierrez and each of those cases. Let's see. Moving on to the amount of spousal maintenance. In this case, the trial court looked at the facts of the case and made the determination that it would be just to provide wife with $500 a month for 10 months. It didn't necessarily look at her reasonable needs and her ability to meet those needs. It just decided what it thought would be fair to husband. The trial court explicitly found that her anticipated expenses exceeded her income. The gap can increase if her parents are not able to assist her, if her disability benefits decline, or if her medical condition worsens. So again, it's our position that this should be sent back to the trial court, and wife's reasonable needs should be taken into account, and the amount of spousal maintenance, the indefinite amount of spousal maintenance, should be determined based on the reasonable needs and husband's ability to pay. Finally, we get to the fees section. And in this section, the trial court used a prevailing party theory to decide what amount of spousal attorney's fees should be awarded. It specifically stated that the court will consider the discrepancy between the relief wife requested and the relief granted when evaluating the reasonableness of her requested fees. In Etzel, the Supreme Court has stated the purpose of awarding attorney's fees is to ensure that the party with the least resources has the ability to properly litigate the issues before this case. In this case found just recently in Bobrow that a prevailing party theory is a violation of public policy. So in this case, the trial court
Are you saying the court can't consider at all the merits of positions taken by the parties?
Well, the trial court explicitly found Number one, and I'll read its findings, the trial court found that there is a substantial disparity of financial resources between the party. Husband earns far more than wife, and wife is unable to work due to her medical condition. Thus, husband has considerably more to contribute towards wife's fees and costs. The court then states that the court further finds that the wife did not act unreasonably. So it already found that she was not unreasonable in this litigation. And then it goes on to say, the court notes, however, that wife requested a modification award of indefinite spousal maintenance of at least $1,000 per month for an indefinite duration. It then did a prevailing party standard, which is the court will consider the discrepancy between the relief the wife requested and the relief granted when evaluating the reasonableness of her requested fees. It states that, but it had already stated that she was reasonable. And so the prevailing party theory, again, is contrary to law. It's contrary to Bobrow. Furthermore, in Roden v. Roden, the Court of Appeals, this court states it's an abuse of discretion to deny attorney's fees to the spouse who has substantially fewer resources unless those resources are clearly ample to pay the fees. So in this case, the trial court used an incorrect theory when it awarded the spouse or the attorney's fees to mother. So again, to reiterate the fact, the trial court abused its discretion when it explicitly found that wife can't work. She can't meet her reasonable needs. It explicitly said that she met her burden of proof that there was a change of circumstances. Established that she will never be able to work again. It found that husband could meet his reasonable needs while meeting mother's or wife's needs. It also states that wife established that she is unable to work again, that she almost inevitably will not return to work again. I mean, all throughout these findings, all throughout these findings, the trial court over and over, wife can't work, wife can't meet her reasonable needs, wife's parents were helping her out but can no longer do so. And instead of awarding an indefinite amount of spousal maintenance, only awarded 10 months. Again, the amount we think needs to go back to the trial court and the award of attorney's fees also. If there are no other questions, I'll reserve the rest of my time for rebuttal.
Good morning, Your Honors. Max Hansen on behalf of Jeffrey Wasserman. I want to address first something that opposing counsel had said during her opening here, which is that indefinite spousal maintenance in a case like this was the presumption. I don't think it's presumption. I think we need to keep in mind the standard here for this court is abuse of discretion when we're dealing with determining the amount and duration of spousal maintenance. Rainwater and Schroeder both talk about that indefinite award is within the discretion in those circumstances that were outlined in those cases, is within the discretion of the trial court to make. Within the discretion. That doesn't mean it's the presumptive, hey, if we have this scenario where wife can't work, automatically the presumption is that it's indefinite spousal maintenance. Neither one of those cases stand for that. Both of those cases indicate the court has discretion to do an indefinite award, but it certainly isn't required to do so, and it certainly can judge it within its discretion to come up with a just and fair award pursuant to 327. And 319. That goes into what the court's questions were on sort of this is an abuse of discretion standard. This court, because it's an abuse of discretion standard, I don't think I have to tell this court this, but I will reiterate it, which is what they want to argue is the trial court should have weighed some factors more than others under 319B. That's well and good. That's their argument. But it's not up for this court to reweigh those factors. This court wasn't at the original divorce trial. It wasn't at the modification hearing. It didn't hear the witnesses. It didn't weigh the credibility. It didn't see the parties, weigh their credibility, and look at all the circumstances. It was up for the trial judge based on
There
his...
really aren't credibility questions here. I don't think anybody, are there? It seems to me there's no dispute that the wife's unable to work, and
I think there was a dispute on whether wife was unable to work. We still had a dispute from our expert, Dr. Merrick. The only thing that had changed, and this was pointed out specifically by the trial court, was that the Social Security Administration had, when they originally had the case, had denied it the first time. It went back on review. It was remanded for further review, and this time they granted disability to wife. That was the only thing that the court found was a material and substantial continuing change.
I guess what I'm getting at is the Superior Court resolved the issue of whether wife can work, is able to work, and said she's not. So I mean, it seems to me we're not here really looking at disputed facts. You're not really challenging the trial court's finding on that.
I'm not challenging the court's finding on that. We're not the ones who filed this appeal. What I'm saying is the court then had discretion to fashion a just and fair award based on the factors as far as amount and duration, based on the factors of 319B. And it went through those factors pretty thoroughly in its under advisement ruling. The court has discretion on how much it wants to give weight to any individual factors. That is clear from the Arizona case law on this. It's clear from Rainwater. It's clear from Schroeder. There is no presumption that the court has a certain fact pattern and automatically the presumption is it has to find this.
Could you comment on counsel's suggestion that there's a public policy exists somewhere that says under these circumstances that indefinite spousal support is indicated?
I think the public policy is discussed in both Schroeder and Rainwater, that the public policy generally behind spousal maintenance, one, is it's rehabilitative, to strive towards getting the spouse receiving the support back on sort of financial independence or somewhere there close to. And there's also a public policy that runs somewhat parallel to it and somewhat counter to it at some points, where the legislature also has put into place a public policy that it prefers not to have basically former spouses, etc., children on the public welfare rolls. But even with those policies in place, the trial court has an obligation and discretion to fashion a just and fair order based on the circumstances and based on its evaluation of the factors set forth in 319B. There's a reason for that discretion. As Your Honor pointed out in your question, isn't there a difference between a 30-year marriage, someone that may be older, that raised children, that put someone through school? Is there a difference in that situation from someone who's been married a month? I would say yes, and that's why the trial court is given discretion to fashion a just award. And that's what the trial court attempted to do here.
How does that award in this case advance the goal of rehabilitation?
It probably doesn't, but this is one of those cases where I think it's difficult for the court to fashion an award that's going to be satisfactory to either side. This is a short-term marriage. The court has to sort of balance the needs of wife for some support, although I would keep in mind that between the time that this modification was filed and by the time we went to trial or hearing, evidentiary hearing on it, we're talking about an almost 4-year period in which wife survived fine. On the other hand, we're also looking at ability to pay and sort of what, if marriage is a contractual arrangement, and I'm not saying that's the entirety of it, but looking at it as a contractual arrangement, is that really the bargain that was sought to be struck? Is I could end up, after a very short-term marriage, supporting this person for the rest of my life, and instead of public assistance, it now becomes where the state is requiring a private citizen to provide that assistance. I think that's the balancing that the trial court had to make here, and that they did. Otherwise, we get in a situation where, it's almost like a lottery winning. Well, I picked well, and I happened to get disabled during this short-term marriage, so now all of a sudden, it's indefinite award of my reasonable needs for life.
Well, was the 10 months tied to some event in the future that was going to provide a substitute income stream?
I think the way the trial court fashioned it, as far as the 10 months, was it went from January of 2013 to October of 2013. After that was when it was remanded as far as Social Security, and when she started shortly thereafter receiving her disability payments, etc. So it was basically trying to give her some support for that in-between time while that Social Security case was pending.
I thought there was an award after the Social Security payments, the Social Security determination was made. Does the award not continue after the point in which Social Security payments are being received?
No, the court limited it to 10 months and dated those 10 months from January 1st, 2013 to the end of October 2013.
And that's when did the Social Security payments commence?
I think, I'm not positive, I think the favorable decision came out in 2014, and then the payments commenced along with a lump sum payment because it was backdated to the 2009, came out in about the early 2015. Now, I would say the same thing on the amount. They complain about the amount. Again, the complaint seems to be based on this idea that, well, it has to be her reasonable needs, it has to be a certain number, etc. Again, this is within the trial court's discretion and how it weighs the factors under 319B, which is definitely within their discretion. It's not for this court to question the weight and sufficiency of how it weighs those factors. It's just for this court to look at to see whether there was any reasonable basis for that. On the attorney's fees, I want to talk a little bit more about that because I think opposing counsel missed the point both in their briefs and here today. When the court looks at their threshold question is whether they can award fees. In a family law setting that's under 25-324, as this court's well aware, the court has two factors in which gives them the ability to award fees or have a party qualify for fees. They look at whether there's financial disparity between the parties, and they look at whether there's been unreasonable behavior by one party or the other leading to further fees for the litigation. Those are once they find under that threshold, this isn't something where they're mandated to award fees at that point. Making a finding, the case law is pretty clear, and I think I've indicated that in the brief. The Myrick case outlines it, I think, specifically. Just because they find a disparity of income or in financial resources doesn't automatically mean the court has to award fees. It still becomes in their discretion whether they want to award all the fees, a portion of the fees, or still none of the fees. And again, that's within the court's discretion. This is, again, an abuse of discretion standard. So I think that's the first sort of error that opposing counsel sort of has gone is, well, if we find this under 324, then she should have been awarded all her fees. The other thing that I think they misread is, even if the court was going to award wife fees here, which the court said, I'm going to award wife her fees because I find there's a financial disparity, the court is only obligated to award her her reasonable attorney's fees. The reasonable nature of the fees themselves is a whole separate question, underlying question, beyond just the finding of whether a party was unreasonable or not to justify an award of fees under 324. The reasonableness of the fees themselves goes into why the China doll case, the bomb case.
That seems a little bit different, though. Are you, I guess I was understanding, maybe you're understanding the argument the same way, when the court said it wasn't unreasonable for wife to pursue the relief that she's seeking, but I guess I didn't read that as, but it's necessarily not unreasonable the extent of the relief that was requested. I guess I'm not sure. Are you viewing? I'm understanding wife's argument to be that when the court said she was reasonable, that kind of ends the inquiry on how reasonable is there a level of reasonableness. It's certainly not a frivolous argument, but does that justify an entire award?
I think that ends the argument, Your Honor, as far as the 324 basis, that wife was found not to be unreasonable, her actions weren't unreasonable. But when the court's awarding fees, the court is awarding wife her reasonable attorney's fees, which go to the fees themselves, which is then why it's sort of another layer there. It isn't that her actions were unreasonable under the 324 threshold. It's whether the fees that she's actually requesting are reasonable in and of themselves. And we go through the factors of China doll, et cetera. That's why we do the China doll affidavits, is to determine, okay, wife wasn't unreasonable in the position she took at trial, et cetera, but wife's fees for what we have here, which is essentially a one-issue proceeding, limited discovery, and so forth, asking for, in this case, over $57,000 when combined her attorney's fees and her own trial exhibit for the divorce and first appeal, which were much more extensive, didn't amount to that. The fact that there were administrative costs, et cetera, which is why we have the China doll affidavit, the objection period, et cetera, is to determine whether the fees being requested are reasonable in and of themselves. And in doing that, the case law that I pointed out in the brief indicates the judge can use their experience, their knowledge of the case, the circumstances involved. And the judge here clearly indicated that's what he was doing, is when looking at the reasonableness of the fees she was going to be claiming, one, that it would not include any prior fees concerning the initial appeal of this case, but two, that, you know, what she had requested, although not unreasonable for the purposes of the threshold question under 324 of whether she was entitled to an award of fees or not, would be considered in sort of the reasonableness of the fees she was claiming. Now, I think those two are sort of that's the important sort of differential here between what the trial court did on the fees and what opposing counsel is claiming the trial court did as far as a prevailing party standard. I don't think it was a prevailing party standard. And I think the court was trying to look at the reasonableness of the fees that were claimed pursuant to China doll, pursuant to BOM. If the court has no further questions, then I'll go ahead and sit down. Thank you.
All right, just to first address the argument that the trial court looked at the reasonableness of the fees. The court told us explicitly how it determined fees, and it said this court will consider the discrepancy between the relief wife requested and the relief granted when evaluating the reasonableness of her requested fees. So we already know how the trial court evaluated the fees. And as stated in Bobrow and the other cases, that's not the standard that can be used. You look at the reasonableness as well as the discrepancy or the disparity in resources.
But I don't think you really answered Judge Catani's question from the first part of your argument, which was, is the court entitled to consider in the reasonableness portion of the fees, entitled to consider whether the relative merits of the claims that were brought?
No, in the case law that we have with the fees, our case law states that you look at the reasonableness of the parties' positions and you look at the disparity of their resources. In this case, we've found that she was reasonable in bringing her claim.
But do you find that you're completely reasonable if you don't get everything that you've requested? So you're saying you're reasonable, and if you requested, if you make 10 arguments and you prevail on 2, is that different in your mind? That may be different. But you're reasonable in seeking to extend the support payments. But that to me doesn't necessarily convey that you're reasonable in the amount or something else that you're requesting.
Again, I think that the trial court can definitely look at those things, but we don't have to question what the trial court looked at and what the trial court assessed, because it told us it was going to use a prevailing party standard, which again, we have case law that says that's against public policy.
But it did award fees, so we know it wasn't technically a prevailing party standard. It was just a factor that was considered. How much relief was granted?
Right, and the trial court only awarded 9% of the total fees, and asking for an award of indefinite spousal maintenance when a spouse is disabled and absolutely can't work is not unreasonable. A husband requested 0 spousal maintenance ever, and so, that could in and of itself be viewed as unreasonable. So, lost my notes here. Another issue that opposing counsel brought up was the issue of kind of relating indefinite spousal maintenance to winning the lottery. I don't think that is an appropriate kind of analysis here. Wife is disabled, she can't work, she is dependent on people to help take care of her, she is basically homebound. He said that she was able to do just fine without an award of spousal maintenance. Her parents helped her out. They went into debt, as is in the record, to take care of that. They testified that they can't help her any longer because they mortgaged their house. They did all of these things. In addition, the mother of wife got into an accident herself, and there's no more support available there. So to say that she did just fine, I think it's not an accurate portrayal of the situation as it is today. Opposing counsel also discussed that it was an abuse of discretion. That the trial court has discretion to view spousal maintenance. And again, the trial court has to look at the factors within the realm of the law. And if the findings don't meet the law, then there's a mistake of law. And in this case, the trial court again and again and again found that wife was disabled, can't work, can't support herself, can't take care of her reasonable needs. If the court has no additional questions. Thank you.
Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course. And with that, we're adjourned.